Welcome back to another explainer from We in Law. We're a civic education resource hub, and we are absolutely committed to your enlightenment for development. Today, we're unpacking a highly critical, yet honestly pretty often misunderstood piece of legislation: guardianship and wardship under the Nigerian Child's Rights Act of 2003. My goal today is to take this really complex legal framework and break it down into clear, actionable knowledge for you.
But before we get bogged down in all the heavy legal terminology, let me ask you a very real, very grounded question. Who legally speaks for a child? Like, who actually steps in to protect them, both legally and practically, when their natural parents suddenly cannot? It's a heavy thought, I know, but it is exactly the scenario this law is designed to address.
So, here is our roadmap for today. We'll start with the legal scope of guardianship, then look at how guardians are appointed. After that, we'll cover the guardian ad litem, move into wardship and the court's protection, and finally, wrap up with maintenance and care orders. Let's dive in.
Section 1. The legal scope of guardianship, the first layer of protection.
Now, it's actually pretty fascinating how the Act defines the baseline concept of parental responsibility. Under the Nigerian Child's Rights Act, a person appointed as a guardian steps squarely into the legal shoes of a parent. We aren't just talking about offering occasional advice here. It legally encompasses all the rights, duties, powers, and authority that a natural parent has under common law or equity. And crucially, this extends to managing the child's property and estate. A guardian literally has the absolute right to recover or receive property in their own name as long as it's for the benefit of the child.
Naturally, the biological parents are the primary natural guardians of a child. The standard default rule under the Act is super straightforward. Upon the tragic death of one parent, the surviving parent automatically assumes the role of guardian. That is your foundational, automatic layer of legal protection.
Section 2. How guardians are appointed. Planning for the unexpected. But what happens when that default option just isn't available? Or what if a parent wants to plan ahead? Well, the law allows us to plan for these what-if scenarios. A surviving parent or a single parent can legally appoint a guardian using a formal document called a deed, which takes effect upon their death. An existing guardian can even use a deed to appoint their own successor. Now, if a parent chooses to use a will instead, the execution requirements are incredibly strict. The will has to be signed by the testator, the person making the will, or at the very least, signed at their explicit direction. And here's the kicker: you cannot just surprise someone with this immense legal burden. No way. The law clearly mandates that no appointment is effective unless the person appointed actually provides their consent.
That being said, guardianship isn't always permanent. The power to apply for the termination or revocation of a guardianship is not a closed loop. A natural parent can apply, an appropriate state authority can step in, or even the court itself can revoke it if it notices something amiss during other family proceedings. But what I find truly empowering is that the child themselves can apply for the revocation of their guardian, provided they get the leave or permission of the court to do so.
Section 3. The guardian ad litem, specialized representation.
Okay, you will often hear this legal kind of intimidating phrase, guardian ad litem. Let's completely de-jargonize this. While a general guardian possesses broad, everyday parental responsibilities and manages the whole estate, a guardian ad litem is a completely different ballgame. They are appointed by the court solely to represent the child and their best interest during specific legal proceedings. They don't have general parental responsibility. Their battlefield is strictly the courtroom. And inside that courtroom, their authority is absolute. They are selected from highly specialized panels established by the minister. Because of their deep expertise, the reports they submit hold immense evidentiary value, meaning the court relies heavily on their findings to make decisions. To do their job right, they have the legal power at all reasonable times to examine and copy any state or government records relating to the child. They can bring those records straight into the proceedings as admissible evidence. They are essentially specialized truth seekers for the child's welfare.
Hey, if you are finding this structured breakdown of the law helpful and you want to continue empowering yourself with clear civic education, please take a quick second to hit that subscribe button for We in Law. We have a lot more vital legal explainers coming your way, and we'd love for you to join us.
Section 4. Wardship, the court's protection, the ultimate legal umbrella.
So, moving up the ladder of protection, we reach wardship. This is a unique and incredibly serious legal status where the child is placed under the ultimate protection and responsibility of the court itself. And let me be absolutely clear, a child does not become a ward of court through some informal family arrangement or a handshake. It strictly requires a specific judicial order. Furthermore, the exclusive jurisdiction to grant this order rests solely at the high court level of the family court. It's a massive deal.
Because it is such a serious step, Initiating wardship requires strict adherence to the rules set out in the third schedule of the Act. Step 1. You must apply via an originating summons, which is really just the formal legal document required to trigger the application. Step 2. In that summons, the applicant has to explicitly disclose their exact relationship to the proposed ward. And Step 3, if successful, the wardship commences either immediately upon the order being made or upon the expiration of a very specific period prescribed by the court.
Section 5. Maintenance and Care Orders, providing for the ward.
Now, naming a child a ward of court is one thing, but how does the court actually ensure the child is fed, clothed, and educated day to day? Well, the court doesn't just watch from a distance. It actively mandates financial provisions. The court has the power to order either or both parents to pay periodical sums for the child's maintenance and education. These funds can be ordered to be paid to the new caregiver or, and this is interesting, depending on the child's age and maturity, directly into the hands of the ward. When figuring out the amount, the court is bound by the standard of reasonableness, carefully weighing the actual financial means of the person ordered to pay. These orders provide a vital safety net that stays in force until the ward reaches the age of majority, which is 18 years old.
But wait, there is a very specific and highly fascinating caveat in this law. It's known as the 3-month rule. If the court issues a maintenance order, but the ward's parents subsequently resume living together in the same household for a continuous period of 3 months, that maintenance order completely ceases to have effect. Basically, the law practically recognizes that the family unit has reformed and state-mandated financial transfers between the parents are just no longer legally necessary.
Now, what if staying with the parents is entirely undesirable or just impracticable? In those exceptional circumstances, the court can commit the ward to the care of an appropriate state authority. Alternatively, the court can mandate that the ward be supervised by an independent person, like a child development officer. The core takeaway you need to remember here is that the court always retains the ongoing power to vary or discharge any of these orders as the child's life and circumstances evolve.
And to ensure this powerful legal mechanism is respected, the court rigorously maintains procedural integrity. The law explicitly mandates the court to forthwith dismiss any application for wardship that it considers to be an abuse of the court's process. In short, the legal system absolutely cannot be used improperly to settle personal family scores.
Finally, just a brief note on how this interacts with other legal proceedings. The Act includes savings clauses, ensuring that old custody orders made before this law remain valid, as long as they are consistent with it. Plus, if a court is hearing a really messy matrimonial case, like a bitter divorce, it has the authority to step right in and direct that proceedings be initiated to make the involved children wards of the court, ensuring they are totally sheltered from the fallout.
We have covered a tremendous amount of legal ground today, unpacking the robust protections of the Nigerian Child's Rights Act. But I want to leave you by bringing this dense legal framework right back into your living room. Seriously, ask yourself, are the children in your life legally protected if the unexpected happens tomorrow? Understanding guardianship, knowing how to utilize deeds and wills, and grasping the ultimate protection of wardship isn't just theory, it is practical, essential family preparedness. Take these insights, reflect on your own planning, and ensure the vulnerable are always shielded. Thank you so much for joining me for this explainer. Stay enlightened and stay prepared.